And still outlining Chapter 3 hearsay, exceptions to the hearsay rule. We're looking at the 9th, former testimony, if declarant is presently unavailable, which includes depositions and earlier hearings in the same case. There's some distinctions between civil and criminal, which are, for instance, the motive matching, and being barred by the confrontation clause, nonetheless, or despite the exceptions, such as in Crawford versus Washington and Davis versus Washington, and this is covered in FRE 804A and B 1 and CEC 1290 to 1292. The advisory committee note to this section indicates a preference for parties to testify, but if unavailable, to make that a former testimony effective, I have written here oath, cross-examination, demeanor, which is not going to be conveyed, but it's no different than any other hearsay exception. There's a motive factor, interest factor, should be similar. Mutuality now generally discredited, and the substitution of successors by narrowly construed privity can be admissible. Then Park, Leonard, Orenstein, Goldberg wrote a treatises not accepted by public records, testimonial hearsay. I guess that is instead testimonial hearsay. And then you have 801 allows it, and by it, I think we're still talking about former testimony without foundation. Weisenberger, former testimony treatise, talks about a person in privity is a person when present party received right, title, interest, obligation at issue, or a person whom present party received that right. Predecessor in interest, undefined by Congress, but much like a person in privity. Different approaches applied. 1 and 2. I didn't start recording. So for this Park treatise, I'm not sure I'm really making any sense out of that. I'll read it anyway, but I'm not making sense out of it. So former testimony is not accepted by public records, which he treats it as testimonial hearsay. 801 allows former testimony without foundation. Weisenberger, former testimony treatise, defines person in privity as a person whom present party received right, title, interest, obligation at issue. No definition to predecessor in interest, but similar to person in privity. Different approaches applied. Exclude for absence of appropriate motive. Substantial identification of issues existed in both actions and similar motive and meaningful opportunity to cross-examine. Substantially identical. Dying declarations. Sometimes evidence entered by business record for reliability, practical necessity, FRE 804 1242 McCormick on Evidence, Section 309 of 2013. Arbitrary limits, special likelihood of truthfulness of deathbed statements established in the 1700s. Exceptions apply. Advisory Committee on Note. FRE 701, not an opinion. FRE 602, firsthand knowledge. 804, B, 2, less stringent since Shepard case law, only criminal, not civil. Homicide. Since overcome. Since overcome. Circumstantial limit abandoned, not too attenuated. So bringing this together, I have like a little star next to pretty much every line. Okay, so these are all separate thoughts then. That might be what I'm trying to establish by that. I'm not really tying together the breadcrumbs. But anyway, report of the House Judiciary Committee. Lower limit based on attending circumstances. expand to greater criminal, civil with less than 1 year prison sentence, exceptional need for evidence criteria for prosecution to use. Declarations against interest. FRE 804 CEC Section 1230. Rule. Include statements subjecting the declarant to criminal liability and statements tending to make him the object of hatred, ridicule, or disgrace. Advisory Committee note. Reduced object of hatred, ridicule, or disgrace. Prong. Report to House Judicial Committee. Requires unavailability of declarant and corroboration unless corroboratory circumstances clearly indicate the trustworthiness of the statement. Corroborating. Okay, forfeiture by wrongdoing. Common law exception. For when a party falsifies common law, witness is unavailability. This is FRE 804 B, capital B, 6. Note to Advisory Committee Amendment 1997. Need not consist of criminal act. Applies to all parties, including government. PPE standard per FRE 104. Note 2. So we're on to some more cases, and the case number we're up to is 67 at this point. I'm trying a pen to mark this. And my desk is complete slop. This is actually, this is 67. Immigration case, paper save, ministerial. Papers are ministerial, not testimonial. So I don't really know what it's about or what section we just discussed that it falls under. More than likely, it's the first section, which is maybe public records or former testimony. It probably is public records. So put it under that section. Case 67, U.S. versus Torrealba Mendia. Immigration case. Papers are ministerial, not testimonial. Case 68, U.S. (2001). Convicts individual fraud scheme by grand jury indictment, testimony brought in by prosecution against defendant, counter argument, it was complete and court didn't allow additional testimony, which was exculpatory, to be admitted by a defendant. Incomplete. Excuse me. The rule was 804A, former testimony of unavailable declarant is admissible. Exercise of defendant, provided defendant is unavailable due to Fifth Amendment right, is not unavailability for the purpose of this rule per precedent, U.S. versus Peterson. The rest of the analysis is on completeness per FRE 106. Testimony is, or evidence is, incomplete if there's a possibility to mislead a jury. The holding here was no abuse of discretion on the issue of former testimony, and the holding was that the evidence was complete. The test evoked was omission unnecessary to avoid misleading jury, and exculpatory testimony without more make it admissible for completeness. Complete. However, if defendant is unavailable due to Fifth Amendment right, he is not unavailable for the purpose of the rule according to precedent. So highlighted that. All right, good case brief. What was that about? A fraud scheme? Okay. So the next case is Kirk versus Raymark Industries. Kirk read expert testimony from another case. Okay, this is good. This is like contradictory expert testimony. So, it was a mesothelioma case. Okay, so it's about former testimony, so I'm going to put it right under the last case. Case 69, Kirk, Raymark Industries Incorporated, 1995. Decedent's wife brings cause of action for husband's mesothelioma from product he was exposed to in New York shipyard, employed as a painter from 1950 to 1960. The expert gave an opinion for the defense that the plaintiff contradicted by the same expert in an unrelated case. And the defense the defense opposed entry of evidence as hearsay and not accepted by 804. The appeal court remanded. Because of the issue of unavailability of the witness not being met, because the witness could have been subpoenaed and he wasn't. Writer. Case 70, Clay Johns Manville Sales Corporation. Case 71. U.S. Salerno. Case 72, Shepard, U.S., 1933. Decedent told nurse, Dr. Shepard has poisoned me. Test the whiskey bottle before collapsing on a date before she fell ill on 5/20. After. She recovered. Decedent recovered before relapsing again. Doctor assured her she would get better and died on June 15th. The dying declaration, section 1242, California Evidence Code, states unavailable witness made declaration from personal knowledge and under sense of immediate and pending death. The limitation is the statement being spoken without a hope of recovery. Shadow of impending death. This interpretation is supported by case law and Wigmore. And state of mind must be exhibited in evidence, not left to conjecture. And here, victim did not state she was in the requisite state of mind. Decedent's beliefs not sound and or certain, as she asked the nurse to test the whiskey bottle, thus showing an indefinite conviction. Thus, the declaration contradicts common law purpose of the exception that dying declarations bear a, quote, legacy of knowledge, end quote, on which the world may act after she is gone. Knowledge or opportunity for knowledge, not so much stemming from principal versus varying and equivocal conditions. So because this is a case about dying declaration, I'm going to move it down to that section. Or at least right before the section about declarations against interest. Do that. Case number 73. U.S. Case 74, State versus Lewis. Case 75. Davis. Davis was struggling financially and held up his insurance company, taped the employees to chairs, and set the building on fire. Employees that were badly burned died within days and weeks of the fire. And their statements about his identity were admitted. In accordance with dying declaration elements. There's other evidential matters involved in this case because there were other witnesses and they witnessed the car, and the car had evidence and DNA. But this case is meaningful for its depiction of the dying declaration, exception to hearsay. Case 76, U.S. Duran Samaniego. State of mind testimony leads to defendant's conviction from family members that overheard unavailable witness out of court statement apologetic conviction of an associate of that witness who the hearsay evidence is relevant because it provides makes the theory more likely that unavailable witnesses' theft of brothers' boxing champion belts were sold to defendant. State of mind exception does not permit the witness to relate any of the declarant's statements as to why he held the particular state of mind or what he might have believed included that state of mind, quoting U.S. v. Cohen, 1980. More appropriate here is 804 B 3, statement against interest, exception to hearsay, subjects the declarant to civil or criminal liability but requires that declarant unavailable. Which the court confirmed the wrong rule was applied, but the right result was reached. In Miami. Case 76 U.S. v. I'm just moving that case under the declarations against interest section. I have nothing for case 76 U.S. v. Jackson. Now I'm on case 77. Forfeiture by wrongdoing, so I'm going to place it under that section. This is actually a really interesting case. Homicide. $77. 2008. Defendant convicted of murdering girlfriend based on entry of girlfriend's out-of-court statements about prior domestic abuse and threats to kill her to the police, which makes those statements testimonial. According to California Evidence Code, annotated section 1370, when declarant is unavailable and statements deemed trustworthy, because defendant loses right to confrontation if declarant is made unavailable by defendant's bad faith act. The rule, forfeiture by wrongdoing, is a common law doctrine that permits introduction of statements of a witness who was detained or kept away by the means of procurement of the defendant. California's code on evidence makes this by statute overcome the defendant's right to confront witnesses against him. Testimonial prior statements inadmissible nonetheless because the evidence code and Constitution override California's interpretation. Constitutional rights. Federal. Historical analog. Case 78, Voland Golden, City of Chicago. Case ultimately admit testimony about police brutality that led to the death of defendant. Sister takes over civil case and she wants to enter prior testimony from criminal case as predecessor in interest. As his. Per analysis of rule elements, the prior testimony was under the same motivation, involving the same transaction or occurrence, probably under oath and probably subject to cross-examination, but I didn't write that down. Why does under oath keep going as like one word?